long time, the governors are always in news. And the post of governor is a controversial post, and we always know that. And UPSC have asked a lot of questions regarding the post of governor. And in this video, we are going to discuss one of the important articles related to the governor. Hi, it's me, Fatima Nusrin. Welcome to Ekam IAS. From many news articles, we can see a conflict of interest between the governors and the state governments. So, in the recent times, we have seen a conflict between the governor of Kerala and that of governor of Tamil Nadu with their state government. In case of the Tamil Nadu, that was a matter related to the NEET examination, and the governor of Tamil Nadu has reserved that bill for the consideration of president. And in case of Kerala, the Kerala government has publicly said that it will not give assent to Kerala Logayukta Amendment Bill and Kerala University Amendment Bill. So this made us to study regarding the power of governor in relation to the assent of giving a bill or giving an assent to a bill. So the post of governor. So we know that governor is a part of state executive. Also, he or she, that is the governor, is part of legislature like the president. The president is part of parliament along with the Lok Sabha and Rajya Sabha. Similarly, the governor is part of the state legislature. Since the governor is a part of state legislature, a bill only becomes an act when the governor gives assent to that particular bill. Okay. Now let's see what are the powers enjoyed by the governor when it comes to giving assent to the bill. So that brings us to our today's topic of discussion, that is Article 200 of Indian Constitution. Under Article 200, the governor enjoys 4 powers in regarding to the bill. And the 4 powers are: the governor can assent the bill, or can withhold the assent, or can return a bill if it is not a money bill, then can send to the president, or can reserve a bill for the consideration of president. So these are the 4 powers enjoyed by the governor when it comes to the matter of bill. So in case of assent to a bill, that means the governor, after passing from the house, the governor giving assent to that particular bill, and it automatically becomes an act. So that is giving assent to a bill. Then withholding the assent, that is not giving assent or not reacting to that bill. He can just keep that bill aside, not deciding, not giving an assent or not giving back. Okay, so that is withholding the assent. And the constitution has not mentioned any ground in which the governor has to withhold the assent. In certain cases the governor has to withdraw. No. The constitution has not mentioned any certain ground where the governor can withhold the assent. If the governor feels that he or she requires certain time or to go through this bill before giving assent, so he or she can withhold the assent. Then the returning of bill. When a bill reaches the governor, and if he or she felt that it requires certain changes, certain provision has need certain amendments, then the governor can send back this bill to the house. And if they bring back this bill with or without amendments, the governor has to give assent. He or she cannot again resend that bill. Okay, so that is regarding the return of bill. And this returning of bill will not be applicable in case of money bill. The money bill will be introduced in the legislature only after getting prior recommendation from the governor. So the bill will only be introduced after getting permission from the governor. So once it is introduced, then there is no point of governor returning that bill. Okay, so that is why in case of money bill, there is no returning of money bill for the governor. Okay, I hope that point is clear. So then the 4th power is the reserving the bill for the consideration of president. And in constitution, the only ground mentioned for that is if that particular bill will affect or hamper the position of a high court. then the governor can reserve that particular bill for the consideration of president. And constitution has not mentioned any other ground except this hampering the position of the High Court. But courts in certain times have given the discretionary power to the governor in deciding the reserving the bill for the consideration of president. Not the constitution, but court has given that discretionary power. The constitution has only given the power to the governor in case of reserving bill is only for if that particular bill affects any position of high courts. Okay, I hope the 4 points are clear. So I'll sum it up again. The governor has a power to assent the bill, withhold the assent, or return the bill if it is not a money bill, and he or she can reserve the bill for consideration of president. Okay. So these are the 4 powers of governor enjoyed in regarding the assenting of bill. Okay. So that is it. And the other important things that you have to keep in mind when you study the Article 200 or regarding the power of assenting the bill is compare the power of governor with that of the president, and also study regarding the veto power of president and governor. Okay, so that's it. Now let's see a model question. So it's a 3-statement question. Try to find the answer and write the answer in the comment section below. The answer, the explanation, as well as the detailed material will be provided in our Telegram channel. The link to our Telegram channel will be provided in the description below. So that's it for today. I hope you find this video interesting, and if you do, please don't forget to like, share and subscribe. Thank you for watching.